Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which I've reviewed before. The reason I'm reviewing it again is because I've used it more recently, very extensively, and I thought I would do an updated review. It's Advocacy in Family Proceedings, Theory and Practice. It's a bit out of date now, it's second edition, and it's a couple of years old. I can't remember exactly when it was published, 2012, 2013, round about that, so it's about 5 years old now. David Bedingfield is to be congratulated for the book. I've given the amended title this, An Important Guide to Advocacy for Those New to Family Proceedings, and that's the reason why I'm using a new review of this work, because having looked at it again, I thought this was a really first-class book for people who are unrepresented parties, who may start having a few problems and might find that this book will help them. It came originally from Jordan's Family Law. Whether the LexisNexis people are going to publish it again, I don't know. Let's look at the book first of all. It's a paperback. There we go. There's the front, the spine, and then there's the back. Probably can't read much of it. I've not actually taken much from the blurb because this review is a slightly different review. The index is by paragraph numbering at the back. You've got various substantial number of appendices all the way through, guidance notes. It is a little out of date, that's the trouble, because things have moved forward in the family law quite substantially since this was published. But a lot of what's in it is very helpful. There's a dedication, which I'd like you to see there, from the author. I only review books which I think are important. I don't bother reviewing books that aren't very good. This is a very good book. Because I'm not going to be insulting to people who've written books and then go around being rude about them. There's the preface there. This book is a good book and it's actually helpful, and the purpose of these reviews is to tell you what's on the market depending on what you're looking for. That's the preface. The lawyers are stated on the 31st of December 2012, and I think the book appeared in sometime in 2013. You've got the contents section there. You've quite a lot of detail. Then you've got case law. Then after that you've got some statutes, a table of statutes. Then you've got the statutory instruments, and you've then got the PDs, the practice directions. They've not included some of the new stuff because Sir James Mumby made quite a lot of changes before he retired earlier this year. Earlier this year. And therefore that's not included, but so you have to keep up to date. The table of abbreviations is very helpful because there have been some changes in the way we do things. Table of abbreviations and the general principles running all the way through, and you can see paragraph numbering and you can see the footnoting. The reason I'm doing this review again is because it struck me that whilst we haven't got a new edition of this book yet, a lot of the information about how you present the case is what I believe is needed, because there are so many people now who cannot get legal aid, they're not represented, and they really do flounder when it comes to understanding what to do in court. This book I think will help. So if you are a litigant in person, I'm hoping that will assist you. This is what I'm going to say anyway about the book. It's a little bit out of date because I reviewed it some time ago. The content remains an excellent guide to modern advocacy, in my view, in the family proceedings you might have for those who are new to this special jurisdiction. It gives you some very common sense approaches, which is why I've redone this review, because I think, having looked at my original review, I decided that because it's now out a little bit old, the basic principles are still there, because additionally the main points concerning the approach the advocate should adopt in court and with your preparation are applicable, of course, to other types of proceedings, although this is family law, and family law are special types of proceedings, in my view, as a person who is practicing at the family bar, mainly because they offer what I consider to be sensible, common sense series of principles which will be a great assistance to all advocates at whatever level, whether they're professional or not. And this is at a time, of course, as I say, when many members of the judiciary are still expressing substantial concern over advocacy standards at a time of change. Now, some of what Bedingfield says makes sense. Some of it I probably take issue with, but my basic point is that you've got to know what you're dealing with and keep stuff simple, straightforward and relevant. And those are the points, because it's often said that advocacy cannot be taught but is a natural facility which some people possess. I'm sure that's correct. I'm not talking about flowery advocacy and expansive Rompolian type of approaches. It's actually much drier than that, because you've got to know what you're talking about and go straight to the point and make your point succinctly with the judge. And to a point, of course, therefore, when I say this business about you can't teach advocacy but you just have it, that is correct. But David Bedingfield offers us, I think, a contemporary approach to an overall requirement to prepare as carefully as possible before the hearing, because preparation is the key. No method is foolproof, but we do have his suggestions to great advantage at both courts of first instance and on appeal. And I think his observations work, because what he does is he offers numerous practical examples to follow, and it incorporates the collective wisdom of family jurisdiction judges, leading barristers, solicitors and family and expert witnesses. And that, of course, is really what this is all about, because I've been in front of many judges who look as though they're thoroughly bored when I'm talking to them, because they think I may be going off the point. Sometimes I'm not, but I'm making the submissions very carefully, sometimes on instructions, but sometimes purely and simply because that is what the issue is that has to be addressed. Now, what we've also got here are the practice directions, the protocols and the guidelines governing the presentation of cases, plus the appendices. Obviously there is a problem with updating, which I've mentioned, because there are a number of changes that have come in, and you do have to keep up to date. There are certain things concerning the way you cross-examine the other side and so forth. Again, those are points which will be dealt with, hopefully, with a new edition. Because what this book does is it succeeds in providing a guide for the student and the beginning advocate toward understanding the theory and practice of presenting cases to judges involving issues surrounding the breakdown of families. That's what it's about. There's no emotion involved in this. It's got to be very clear, very clinical, and get straight to the point. Its success, then, lies in that no area of law rests so firmly on the advice and evidence of experts, because at the end of the day you've got all this information coming together, and it's a matter for the judge at the end of the day to ask the questions that she or he has a concern about, and you must try and answer them if you can. But the important point, as I've said, is preparing properly right at the beginning so that you have got answers to the questions that are being put forward. And what David Bedingfield does is he seeks to provide a background of research available in each of the most contentious areas of family law, and that's what you've got with the various chapter headings. And of course, of great use is where the text focuses on the latest research regarding topics such as non-accidental injuries to children, always an important area, the evidence of child witnesses and victims, and the difficulties in determining the cause of sudden infant death. That was very topical when the book appeared. At the moment, domestic violence is certainly the very big issue, and that's normally the man behaving badly. Not always, but that's normally what the problem is. And that's actually makes up a lot of the cases being heard in the courts, certainly that I deal with, and what my colleagues do at the family bar. Now, as the author says, his book restates the theory and established rules of good advocacy. And that's the other bit about this book, because if you are doing the bar exams, you might find some of the suggestions in this book, especially about the approach to be adopted, very helpful. It may help you with your practical training exercises and your final assessment for the advocacy exam. Because what he's doing is he's established the good rules of advocacy, and he refines them in the light of specific needs of family advisors at every level. Now, I don't subscribe to the view that family law is totally different from any other area of law, because I do, as a general common law practitioner, a whole range of civil. I don't do criminal, but I do civil matters, and that is tort, breach of contract and so forth, in addition to family law. And the advocacy is still basically the same, although family law practitioners would like to think sometimes that it's slightly different. I think it takes a slightly different approach when you're dealing with very, very worried and upset and emotional clients, but at the same time, I still believe the basic principles are there. So please remember, as I've said, that the appendices are old, and some topics have been revised by the President of the Family Division, quite rightly. We haven't had any new legislation, and we're not likely to get any because of Brexit, but certainly in the future there will be some new legislation coming along, probably to protect some of the witnesses who are vulnerable. In my view, you cannot do without this book if you practice in the family courts, and I think if you are certainly worried about your quality of advocacy, this book will give you some hints. I certainly found it helpful, and I've been an advocate for 30 years nearly. I've certainly found this very helpful indeed, and it gave me some ideas, especially when I go into the higher courts, because they can be a bit daunting. The laws as stated on the last day of the year, 31st December 2012, and it was published on the 12th of February 2013, so it's a little bit out of date. Let's just have a last look at it. There it is, front, spine, and then the back. You can see the back there. Just opening it in the middle. Financial remedies, obviously an important area. I'm going to take you to one area which I found helpful because I did use this for appeals. That's the appeals chapter 7. Appeals are not easy, and in fact Lord Justice Thorpe it was interviewed by the author, and he actually gives a statement about what they're really looking for in the appeal courts. And having looked at it, there are some review, rehearing or appeal. It gives you a lot of sensible advice about what you're doing, because the difficulty is that a lot of the clients have no idea that once you've had your fact-finding hearing, that's basically the end of it, because they're not really, unless something very substantial has changed, they're not going to start altering the final decision of the judge at first instance. That's always been the problem, but I did find the appeals section helpful. Thank you very much to David Bedingfield and to What Was Jordan's Family Law, and hopefully there'll be a new edition before long. In the meantime, I'm most grateful for this book. It does help me, and I'm sure it will help you if you have a matter in the family courts. Thank you very much. Bye-bye.